Good morning, Mr. Moran.
Thank you, Your Honor. Good morning. May it please the Court. First of all, Your Honor, would it be permissible for my client to sit at the counsel table with me?
Certainly.
Shaughnessy. My name is Philip D. Moran, and I represent William H. Shaughnessy, the petitioner for reinstatement to practice law in this Commonwealth after nearly a 7-year period of suspension. Sometimes I have discovered that brevity and specificity is a virtue, and with that in mind, I will attempt to adhere to that virtue. As you are aware from the brief submitted in Mr. Shaughnessy's prior appearances before this Court, he has been suspended from the practice since August of 2003. During that time, despite Attorney Weisberg, and I might add the hearing panel's contention, I would submit that Mr. Shaughnessy has complied with the requirements set forth by this Court in the matter of Daniels in 2004 to be reinstated. And if I may, I'd like to address those criteria. First and foremost, I submit that William Shaughnessy does have the moral qualifications, competency, and learning in the law required for admission to practice law, and his resumption will not, and I repeat, will not be detrimental to the integrity and standing of the bar, the administration of justice, or the public interest.
Mr. Moran, excuse me.
Yes,
I don't mean to interrupt. Was I the single justice on this case?
No, you were
No,
not.
Justice Brodsky.
Justice
Okay, all right.
Brodsky.
Okay.
It's been here before.
Yeah, I was going to say you look familiar. It's just...
My reasons for that conclusion are, first, the original offense, which was no doubt serious, was, however, viewed by this Court as an offense that required a 6-month and 1-day suspension after you reversed Justice Sussman's original penalty of 1 year and 1 day. Second, although Attorney Weisberg concludes that the suspension itself is evidence of character, a lack of character and maturity at the time of the offense, and believe me, I do not diminish the severity of the offense, and I recognize that she is quoting from the language recited in numerous prior cases. However, I submit that she fails to give weight to my client's experience, which is one of overwhelming magnitude. Mr. Shaughnessy was a trial attorney for many years, with what could be best described as an outstanding talent and compassion for the underdog. He performed a great service to the integrity and standing of the bar by virtue of being willing to try cases that many others wouldn't be bothered with. He represented a myriad of individuals who needed an advocate that would fight diligently for their respective rights. Cases like the Richard Crowell case or the William Cody case decided in his favor by this Court against what others said were overwhelming odds come to mind. I submit these reflect more of his character and maturity than the events that bring us here today. This is an individual who is a board-certified trial advocate. He taught trial skills alongside Judge Shaughnessy, Judge Nelson, and Judge Sullivan at Harvard Law School and the Western New England School of Law. He served as a judge at many moot court competitions, and he at several of the local law schools, sat on numerous medical malpractice tribunals during his many years as an outstanding trial attorney. Board certification by the National Board of Trial Advocacy is reserved only for those individuals who possess the experience and competence to which most practitioners aspire but never achieve. Third, again, to read the opinion of the hearing panel in Attorney Weisberg's memorandum, his conduct and occupation since 2003 is somehow irrelevant. As I stated in my brief, he has been on trial since his suspension in his pro se defense of his home and his own reputation. This is not only relevant but critical to determine what he has been doing since August of 2003. A review of the supplementary appendix will verify he's been on trial throughout most of that time. Since then, at the United States District Court, the United States Court of Appeals, and the United States Bankruptcy Court on his own basis, on a pro se basis. Fourth, the time elapsed since his suspension, as I stated earlier, going on 7 years. Some of this time is by his own action or inaction. But again, 7 years is a lifetime in Mr. Shaughnessy's career, and just seems totally unjust based on the totality of the circumstances when one recalls that the original suspension as amended was 6 months and 1 day. Although this court in the matter of Al-Jahis stated that the passage of time is insufficient to warrant admission, the court in the matter of Harvey Prager did say, and I quote, "It is appropriate to consider in a reinstatement procedure the amount of time that has elapsed since the suspension." Indeed, as I was preparing for today, the thought kept crossing my mind, what does a 6-month and 1 day suspension really mean? Does it mean that it's 6 months and a day, or 1 year and a day if Ms. Weisberg and the BBO agree? Or does it mean 6 months or 1 year as determined by this honorable court? Fifth, his present competence and legal skills, by virtue of his pro se activity during his suspension, raised the sharp. And as I have said before, trying a case is like riding a bike. Once you learn it, you never forget.
Forgive me, Mr. Moran, could you just address the hearing panel's particular focus on Mr. Shaughnessy's reinstatement questionnaire, which it said contained evasions and omissions and, a variety of other complaints?
I did look at his questionnaire, Your Honor, and on that particular score, I'm not sure I disagree with the hearing panel. It was not as well done as it could have been.
Well,
however, I'm not sure it was quite as bad as they make it out to be.
Well, shouldn't that be of some concern to us? I mean, when you're applying for your license to be reinstated?
I agree, Your Honor. He could have been less evasive or more, not as vague as he was, but I do believe that the answers to the questions were there. They might not have been as clearly stated as the hearing panel would have liked, but I think Mr. Shaughnessy did answer the questions.
Thank you.
In any event, he was by all accounts an outstanding trial lawyer, and according to the hearing panel, which I will quote from, "It is difficult to disagree with Mr. Mons, his prior counsel's statement, that this is a man whose life has shown substantial moral character. It has been a life marked by fortitude and perseverance. It has also been a professional life in which, despite his considerable financial difficulties, there has not been made even a suggestion that he ever touched a penny of client money. I submit, and I agree with the hearing panel, that his moral standing is above question. And I would also submit that his competency and learning in the law is above question. I would also submit his reinstatement will in no way, and I repeat, no way be detrimental to the integrity and standing of the bar, the administration of justice, or the public interest."
Without going back to it, it seemed to me that what the hearing panel at least was saying is, while not necessarily agreeing with the issues of, addressing the issues of competency, was saying, next time, fill out a full, complete, what are the words?
Questionnaire.
Clear, complete, and unequivocal answers to the questions presented. Now, this was in January 2009, right?
Yes, Your Honor.
So here we are, almost a year later, and they were recommending that that be done in 6 months.
But then that was included to increase to a year.
Yeah.
And my concern is that we go on and on and on. The next time the hearing panel would say something else. Your Honor, as you well know, the license to practice law may not be withheld arbitrarily or discriminatory.
Sure.
And my client and I fully recognize, while deference should be given to the board, it is this honorable court that retains the ultimate authority to decide a person's fitness to practice law in this Commonwealth. And I respectfully request on his behalf that you use that authority and that you reinstate William H. Shaughnessy and give him an opportunity to redeem himself. As I said in my brief, enough is enough. Please reinstate Mr. Shaughnessy.
Thank you, Mr. Moran. Ms. Weisberg?
Thank you, Your Honor, and good afternoon. May it please the Court. The issue, of course, is not what I think or what Bar Counsel thinks. The issue is whether there was any error or abuse of discretion in the single justice's decision to deny the reinstatement petition that's before you now, as was recommended unanimously by the Board of Bar Overseers. I needn't remind the court that the burden was on the petitioner to prove three things, and that the hearing panel unanimously found that he had proved none of them. And I would suggest to you that there is ample evidence in the record to support those determinations, and that nothing that has happened since, including what has been inserted into the record after the fact in this appeal or stated in the brief, has changed that. I do think it's important to note one thing at the beginning, however, which is that this case should not even be before the court at this point on the merits, because Mr. Shaughnessy waived his objections to the hearing panel report and all other objections on the merits of the hearing panel's decision when, at the time when he was represented by Mr. Moan, he did not appeal or file any objections with the Board of Bar Overseers. Rule 3, Section 3.50, subsection C of the board rules says that when you don't file objections to the board, you are deemed to have conclusively waived all objections to the findings and conclusions, and the court has, in other cases that I've cited, upheld that proposition. And there really is no reason why Mr. Shaughnessy should not be held to that standard, as are all other litigants before the Board of Bar Overseers. So I would suggest, and I would suggest to you that it's telling that in Mr. Shaughnessy's brief, he doesn't even mention that problem, which was the primary basis for Justice Botsford's decision, that is the decision of the single justice denying reinstatement. If you do, however, nonetheless decide to reach the merits of this appeal.
I'm sorry, before you get there, if we do affirm the order of Justice Botsford, when do you say the 1 year ends?
I'm afraid I have to say that the 1 year ends when this court enters a final judgment.
Because Justice Botsford's order says it enters 1 year from the date of her order.
I understand that. Under section, let me put it differently, perhaps there was an anticipation that there would not be an appeal to the full bench. But section 18.8 of the rules, of this court's rules, Rule 401, section 18, subsection 8 says that except as the court may order, no lawyer shall be permitted to reapply for reinstatement or readmission within 1 year following the final disposition of an adverse judgment.
But here's the confusion I have. The board says he should not apply for 1 year as of the date of its decision, which was April 13, 2009, which would mean he could, if he had not appealed, could have sought reinstatement next week. He goes for the single justice, and now the date's moved back to June 29th. What do we... The problem is that if we affirm an order of 1 year, we're affirming actually more time than the board sought. We're agreeing to a later date for the petition for reinstatement than the board itself sought.
Can we affirm the board's order and effective nunc pro tunc?
This court has authority under subsection 18 to modify the 1 year rule. To go back to Justice Gantz for just a moment, I'm looking at the board vote, and the board vote was that the petition for reinstatement be denied, and that the panel's recommendation for a shorter period be rejected, and that panel's recommendation as characterized in the vote was that he be permitted to file a new petition without having to wait a year as required by the rule. I don't think anyone was focusing on that point, on when the 1 year would apply. I can't say what was the single justice's intent. I can only say that had there been no appeal, the 1 year clock would have started then. Now it's almost a year later, I understand that. And the question is, Can this court shorten that time now? The answer is yes, of course.
Well, I think the question is well put by Justice Ganson. The question really is, should the petitioner, the attorney, be penalized for taking an appeal, which is what's going to happen? He'll get a double suspension. A double length of time.
I'm sorry, I didn't mean to interrupt. I've thought about that, naturally, and it's an important question. And it's a particularly important question in the context of this very long period of suspension. And I would say the answer is answered by the appeal itself, in a way. Obviously, if this court reverses the single justice's order and orders reinstatement, it's moot. If you were to deny reinstatement, but to determine that there were legitimate claims, that there was reason to pursue this appeal, then you might think, gee, maybe another year is too long, and might consider a reduction of the 1-year period. But we are arguing this case on an appeal that was waived by this lawyer before the board.
But you took an appeal from the hearing.
Excuse me?
You took an appeal from the hearing.
We took a limited appeal on the limited issue, and there was a limited response limited to that issue.
No, I understand that.
And the rule is clear that you waive issues you don't appeal. And
So is judgment final for purposes of this inquiry? Was it final way back then?
was the single justice's order final?
Well, it's an interesting academic question, but the rule says, except as otherwise ordered by the court, we do have the authority to set the time.
You would have still had jurisdiction to hear other matters, but the merits of the appeal, it seems to me, were waived at the time. Let me put it that way.
Sorry.
Yes, please.
I mean, it seems to me that this is truly catch-22. The hearing panel makes a recommendation which the petition accepts. You take a limited appeal. He gets a worse sanction from the board, and you're now saying that he's waived everything. I mean, it just can't be.
I'm sorry if I haven't focused this correctly. The sanction, first of all, there's no issue of sanction here, with all due respect. The issue is whether or not Mr. Shaughnessy has proved that he's fit to resume the practice of law at this point and trustworthy enough to be, as the cases say, certified by this court to go back out into the world. I would suggest that if you reach the merits, there is ample evidence that the two problems that Mr. Shaughnessy had from the very beginning of the case leading to his suspension, lack of candor and lack of insight, have not been solved by Mr. Shaughnessy, and that, on the contrary, the hearing record, as referenced by the panel, shows the contrary, that Mr. Shaughnessy is still plagued by those problems, lack of candor and lack of insight, that cast severe doubt on his fitness and trustworthiness as an advocate at this time. To go back to the Chief Justice's question, the panel made a recommendation to reduce the ordinary waiting period for reasons it articulated. The panel essentially said, we think that his presentation was incoherent, it was marred by it was pervaded by lack of candor, he continued not to show insight, but we think if he tried again, he could do better, and said, we'll let him do it again in 6 months if he does it the right way. Tell the truth, be complete, don't evade. The panel was recommending a reduction for the sole reason that Mr. Shaughnessy hadn't met his burdens, but might, if he could, if he had another go at it. My suggestion is that's no different from the roadblocks facing any other unsuccessful applicant for readmission. And if the board were to endorse this shortened period purely on the idea that another chance might be successful, then the exception would swallow the rule, and there would be no reason for the 1-year waiting period. So I'm suggesting that Mr. Shaughnessy lost nothing except a recommendation by a panel to deviate from the court's ordinary rule. And the recommendation by the panel to deny reinstatement was unanimous. The recommendation of the panel to shorten the suspension, which would have been a dramatic departure for the board, was unanimously rejected. And all along the way, either during the initial appeal period, from the hearing panel's report or after I filed the limited appeal for Bar Counsel, at no point during that time did Mr. Shaughnessy contest the denial of the recommendation of the denial itself. So I don't think I hope the court will focus on the fact that Mr. Shaughnessy didn't lose anything by appealing. Mr. Shaughnessy lost his right to appeal by not appealing at the time.
What happened between 2003 and 2008?
In 2003, Mr. Shaughnessy's suspension became effective on August 2nd, 2003. On July 20th, 2004, this court, in its first full bench decision, reduced the suspension to 6 months and 1 day. The 1 day was added on account of Mr. Shaughnessy's problem with lack of insight, and that's expressed in the opinion. Then, in August of 2004, the county court entered an order for 6 months and 1 day based on the full bench decision. In June of 2005, Mr. Shaughnessy was eligible for reinstatement almost immediately at that point, but didn't reapply immediately. And then in May of 2005, we brought a contempt petition because Mr. Shaughnessy hadn't stopped practicing law in 2 cases. The single justice found him in contempt in June of 2005, had to, under the rules at the time, impose another 1 year and 2 days of suspension based on his continued practice of law.
Who was that single justice who found him in?
That was the late Justice Sussman.
Okay.
In July, Mr. Shaughnessy became eligible for reinstatement under the lengthened period imposed, and that went up to the full bench, and this court affirmed the contempt order in April of 2006. Mr. Shaughnessy became eligible for reinstatement under the lengthened order on July 2nd, 2006, by my calculations. But for reasons that were never explained in the record, he waited till March 31st of 2008 to file his reinstatement petition.
Has this issue ever arisen before where someone would have been reinstated sooner but for the fact that he appealed?
Not to my knowledge. And the issue, and by the way, no, not to my knowledge, but I can't say it hasn't. I just didn't find it.
And that, I think, is an answer to Justice Cowan's question, and unless she has other questions, your time is up.
Thank you.
Thank you, Ms. Weisberg.